In 2016, a lawyer deliberately deleted one sentence from his own complaint by design. That single deletion triggered an insurance clause that stripped $140 million in coverage from one of America's most powerful digital media companies. And the defendant had no idea until the jury came back. What you are about to hear is not a standard lawsuit. It is a coordinated, years-long dismantling of a billion-dollar media empire, secretly funded by a Silicon Valley billionaire who never appeared in a single court filing. Here is how. Gawker Media launched in 2003, founded by the British journalist Nick Denton out of a Manhattan apartment. By 2015, it operated 7 distinct digital media brands, Gizmodo, Jalopnik, Kotaku among them, reaching roughly 25 million unique monthly visitors. That is an audience roughly equal to the entire population of Australia, built on one editorial principle: publish whatever is true, regardless of who it damages. Terry Gene Bollea, Hulk Hogan, was not a private man. He had spent decades broadcasting his personal life to audiences of millions. His marriages, relationships, and bedroom conduct were subjects he had discussed openly on The Howard Stern Show, in a published memoir, and across multiple reality television series. Under American law, public figures who voluntarily publicize their private conduct narrow their own legal expectation of privacy. Gawker's entire defense rested on that principle. They were confident it would hold. In October 2012, Gawker's editor-in-chief, AJ Daulerio, published a 2-minute excerpt from a secretly recorded sex tape featuring Bollea and Heather Clem, the wife of Bollea's close friend and radio host Todd Clem. Gawker embedded the video directly on the site, with commentary. 2 legal time bombs started counting down simultaneously. Neither side fully understood both of them yet. Bollea's personal attorney fired an immediate cease and desist letter. Nick Denton refused to remove the video. His position was straightforward. Hulk Hogan had voluntarily made his sex life a public topic, and a journalist publishing truthful information about a public figure's conduct is protected under the First Amendment. It was a legally defensible stance. Bollea's team filed a federal lawsuit seeking an emergency injunction, a court order requiring immediate action to take the footage down. U.S. District Judge James Whittemore denied it. He ruled that Bollea's extensive public disclosures about his own private life meant the footage might qualify as protected speech. The federal denial should have been discouraging. It clarified something instead. Federal courts apply a stricter First Amendment framework than state courts. Bollea's attorneys withdrew the federal case entirely and refiled in Florida State Court in St. Petersburg. Judge Pamela Campbell granted the injunction. Gawker removed the video and then published links to mirror sites hosting the same content. Denton released a public statement calling the court order risible and contemptuous of centuries of First Amendment jurisprudence. That statement was a gift, not to Bollea, to the jury that would eventually read it aloud. Here is what Gawker did not know at this point. Bollea was not funding this fight himself. In 2007, Gawker had published a separate article outing Peter Thiel, the PayPal co-founder and venture capitalist, as gay, without his consent. Thiel's net worth at the time was approximately $2.2 billion. He spent the next 9 years quietly building a legal response. Not a personal lawsuit, a system. He retained a team of attorneys with a single brief: identify viable claims against Gawker, locate sympathetic plaintiffs, fund their litigation to completion, and collect nothing in return. His firm identified Bollea's case as the optimal vehicle. Thiel covered all legal costs on the plaintiff side. He had no contract to share in any financial recovery. He did not want money. He wanted Gawker to stop existing. Legal scholars now classify this strategy as malice maintenance. Maintenance, in its original medieval English legal sense, was the crime committed when a wealthy nobleman bankrolled another person's lawsuit purely to destroy a rival, with no legitimate legal interest of his own. Most American states abandoned maintenance restrictions decades ago, viewing third-party litigation funding as a mechanism for leveling the playing field between underfunded plaintiffs and wealthy corporations. Thiel was about to demonstrate, at considerable personal expense, exactly why those restrictions had existed in the first place. The insurance bypass was surgical. Under standard commercial media liability insurance policies, an insurer is legally obligated to fund a defendant's legal costs as long as the complaint contains at least one viable negligence claim. That is, a claim based on careless or reckless conduct rather than intentional wrongdoing. This obligation is called the duty to defend. It is how media companies survive expensive litigation. The insurance carrier pays the attorneys, not the company itself. Standard policies strictly exclude intentional acts. An insurer will not pay for what a client chose to do deliberately. Bollea's original complaint included a claim for negligent infliction of emotional distress. That single allegation kept Gawker's commercial insurers, including a carrier called Allied World, legally bound to fund the defense. Then, shortly before trial, Bollea's attorneys quietly removed it. Every negligence-based allegation was stripped from the complaint. What remained were exclusively intentional tort claims, invasion of privacy, and intentional infliction of emotional distress. The legal theory that a defendant's conduct was so extreme and outrageous that it deliberately caused severe psychological harm to the victim. Allied World reviewed the revised complaint, applied the standard policy exclusion for intentional conduct, and discontinued coverage. $140 million in insurance backing? Gone. Gawker's total estimated operating assets at the time were approximately $250 million. The trial had not yet started. The trial ran 2 weeks in March 2016 in St. Petersburg, Florida. The jury pool was drawn from Pinellas County, Hogan's home region. These were not the tech-savvy urban millennials who made up Gawker's core readership. They were local Floridians who had watched Hogan as a childhood icon, now sitting in a courtroom listening to a Manhattan-based tabloid outlet explain why publishing his sex tape served the public interest. The trial's most catastrophic moment came from Gawker's own witness. During his pre-trial deposition, a formal recorded questioning session in which a witness answers questions under oath before trial, AJ Daulerio was asked where he drew the ethical line. Would there be any celebrity sex tape he would decline to publish? He replied that he could only imagine refusing if the footage depicted a child under the age of 4. He later testified at trial that he was being flippant, responding sarcastically to an aggressive line of questioning. The jury had watched the video deposition. They formed their own conclusion. This was not, it should be noted, a particularly effective moment for the defense of press freedom. Gawker's case fractured further when Todd Clem, the man who had secretly made the original recording and stored it in a labeled desk drawer, invoked his Fifth Amendment privilege against self-incrimination and refused to testify at trial. The Fifth Amendment protects a witness from giving testimony that might expose them to criminal liability. Clem had previously told federal investigators that Bollea was fully aware of the recording. At trial, he went silent. That testimony was the only available evidence that could have established Bollea's consent. Without it, the jury was looking at footage of a man who, visually and legally, appeared to have no idea a camera existed. Bollea's attorneys argued a precise legal distinction to the jury. Hulk Hogan, the public character who had discussed his sex life across multiple media platforms, was legally distinct from Terry Bollea, the private individual who had never consented to being filmed. This is a legitimate and well-established doctrine in American privacy law. A person can be a public figure in certain contexts while retaining a legally protected private sphere in others. The jury accepted the distinction entirely. By the final day of closing arguments, Gawker was self-funding its defense with no insurance backing. Its primary consent witness had refused to testify under oath. Its editor had made an on-camera remark about the age threshold for acceptable content that plaintiff's counsel had already played for the jury twice. Its founder had described a court order as risible in a public statement, now part of the trial record. The company held approximately $250 million in assets. The verdict had not yet been announced. The jury deliberated for 6 hours. Then, they returned. $115 million in compensatory damages. That is roughly the annual operating budget of a full-scale regional medical center in the United States. $15 million more in punitive damages directly against Gawker Media. Punitive damages being the additional financial penalty a court imposes specifically to punish deliberate misconduct, separate from compensating the victim. $10 million against Nick Denton personally. $100,000 against AJ Daulerio. Total judgment, $140.1 million. Gawker appealed. Florida law required the company to post a supersedeas bond, a court deposit equal to the full judgment, placed to guarantee the money exists while the appeal proceeds. Daulerio, total judgment, $140.1 million. Gawker appealed. Florida law required the company to post a supersedeas bond, a court deposit equal to the full judgment, placed to guarantee the money exists while the appeal proceeds. By statute, Florida caps this bond for corporate defendants at $50 million. Gawker could not post $50 million without immediately liquidating core operating assets. The company filed for Chapter 11 bankruptcy protection in federal court on June 10, 2016. Chapter 11 is a federal legal mechanism allowing a corporation to reorganize its debts under court supervision rather than liquidating immediately. The bankruptcy filing triggered the automatic stay, a provision under Section 362 of the U.S. Bankruptcy Code that immediately halts all state court collection efforts and judgment enforcement, shifting control of the debtor's assets to the federal court. A court-supervised auction followed. Gizmodo, Jalopnik, Kotaku, and the remaining operating brands sold to Univision Communications for approximately $135 million. Gawker.com itself, the original site, the flagship, was excluded from the sale. It shut down permanently. Bollea settled his claims for approximately $31 million. Nick Denton filed personal bankruptcy the same week. Shortly after the verdict, a Forbes investigation identified Peter Thiel as the litigation's financier. He confirmed it publicly. He expressed no regrets. Here is what this case actually changed, and what it means for anyone who creates, publishes, or reads content online. Before Bollea versus Gawker, media law operated on a structural assumption. Journalism organizations had sufficient institutional resources to outlast plaintiffs in litigation, and that financial resilience was itself a form of protection for press freedom. Thiel dismantled that assumption with legal precision. A single private individual with sufficient capital can now identify a sympathetic plaintiff, fund unlimited litigation behind the scenes, design the complaint specifically to sever the defendant's insurance coverage, and execute the entire strategy without appearing in a single public court document. The First Amendment guarantees what happens after a verdict. It does not protect a media company from being litigated into bankruptcy before one is reached. There is also a clause in this story with practical implications for anyone running a business that publishes content, whether that is a media company, a newsletter, a YouTube channel, or a social media account. If your commercial liability insurance does not explicitly include a duty to defend provision covering intentional privacy claims, a plaintiff's attorney can remove your insurance protection with a single pleading adjustment before trial begins, without you knowing it happened until you receive the bill. Risk managers now refer to this technique as the Gawker Maneuver. It has been analyzed in corporate law curricula at 4 major American law schools. Here is the question I want to leave you with. If Gawker had been publishing content of genuine public importance, Not a sex tape, but critical investigative reporting a powerful person wanted suppressed? Would the insurance bypass have worked the same way? Or does the nature of the content change the legal analysis? Drop that in the comments. There is a real debate among media attorneys on exactly that point. If you are watching without being subscribed, now is a good moment to fix that. Next week, we are looking at the non-disclosure agreement that a pharmaceutical company used to silence a whistleblower and then accidentally used to prove the whistleblower's case in court. The company's own legal team drafted the clause. The clause destroyed them. That one posts Thursday.